In Massachusetts, a whiff is no longer enough. An SJC ruling Tuesday says just because a police officer smells marijuana, it's not enough for them to order someone out of a car. The decision comes after a 2009 case. Officers in Hyde Square ordered two men out of a parked car after smelling marijuana. Problem is, voters decided in 2008 having less than an ounce of marijuana is not a crime. The court ruled the officers had no way of knowing how much, if any, marijuana was in the car.
I have to ask, what does less than 1 ounce smell like? Does more than 1 ounce smell differently than less than 1 ounce?
Former Police Chief Stephen Doherty says the ruling makes it very difficult for officers to enforce drug laws and figure out if someone is driving under the influence. If an officer smells alcohol on someone, they can check for sobriety, but simply smelling marijuana is not enough to go further.
The challenge is that if the person is impaired by reason of marijuana consumption and the officer can't ask the person to get out of the car in order to determine the level of impairment, and he lets that person drive off, and 1,000 yards down the road he runs over a pedestrian, guess whose fault it's going to be?
Supporters say the SJC is right on the money and those officers violated the men's rights. Voters, they say, don't want to see police resources wasted on the whim of a whiff.
It's very demeaning for a person to be searched. In this case, you had 4 other police officers that were called and involved in a search. Their time was taken away from things that might have been preventing or solving real serious crimes.
The vote, by the way, in this was 5-1. The one judge who dissented to this argued that a small amount of marijuana may not be criminal, but it may be the basis for enough suspicion that activities involving marijuana that are illegal are going on.